Good
Right.
afternoon and welcome to so many of you. Around 250 people registered for this event, and I'm delighted by such a positive response. Following a ministerial commitment, every crime law firm is being peer reviewed during the course of this contract, and we felt that it was a good time to produce this webinar. So I'm very pleased to welcome Jeff Bell and Philip Whitaker. Jeff is someone that I've known and worked with for many years. We do consultancy work for his firm, and he does consultancy work for my firm. Jeff is managing partner of Stevens Solicitors and has 12 years experience of being a peer reviewer and a senior peer reviewer. Last week, we mentioned to the National Contract Manager at the Legal Aid Agency that we were doing this course, and we decided to ask Professor Avram Sher whether he could supply a person from his team. As many of you will know, Professor Sher came up with the idea and designed the peer review system. I'm delighted that he agreed, and Philip Whitaker is Professor Sher's advisor and consultant for crime peer reviews. The first part of this presentation will be conducted by Philip, and Jeff will present the second half. Please feel free to ask questions using the chat facility. I'll conclude the presentation by putting the questions to the presenters. If there are too many questions, we'll collate them and publish the answers on our website. Copies of the slides will be made available to you, and we may be able to send you some amazing templates and guidance, but I'll explain that at the end. So Philip, I'll hand over to you.
Thank you, David. Hi, everybody. We've had some technical glitches, I'm afraid, so I cannot actually see anything but a frozen screen. So I hope you can hear me okay. Welcome. I am, as David said, the independent consultant for crime peer review in England and Wales. There are 5 categories of law, publicly funded law that is, which have peer review: family, housing, immigration, mental health, and crime. But by far the biggest one is crime. Crime takes up more resources than all the other categories put together. So when I'm talking about peer review, I'm a bit of a one-club golfer. What I know about the other sectors could be written on the back of a postage stamp. So I'm talking about crime peer review. Now, at the risk of all of you nodding off before I've even got into my stride, I need to give you the definition of peer review. So I'll give you the definition, which is a bit dry, and then I'll try to breathe some life into it. So here we go. Peer review is a system in which a panel of independent, experienced legal practitioners assesses the quality of work of other professionals against a set of criteria and levels of performance agreed with the professional community. The intention of independent peer review is to enhance the standards of legal work carried out under public funding. Now, just to breathe a bit of life into that, all that says is that peer review is a tool. It's a tool just as a spade is a gardening tool. But it's a tool for quality assurance of the work provided by criminal defence lawyers. I'll just give you a little bit of the background to where we find ourselves now. The first Legal Aid Act was in 1949. So legal aid is as old as I am. It's giving a secret away. It's always been recognised that publicly funded legal advice had to be up to a certain standard. But the early safeguards were completely useless. I go back to those days, and incredibly, all that it was a tick box that you carried out yourself, you filled in yourself. So the questions were, how good is my advice? Excellent, very good, competent, below competent. So ka-ching, excellent. Do I always confirm the advice I give in writing? Yes. Where ethical issues arise, do I always behave appropriately? Yes. Now, worse still, at the heart of all this was a massive conflict of interest, because in those days, the body that was responsible for policing publicly funded criminal defence lawyers was the Law Society. But the Law Society was also the body responsible, indeed founded, to support lawyers. So the Law Society was the prosecutor if anybody failed to come up to standard, and also the defence advocate. So that obviously was absolutely useless, and something had to be done. I should add, try to demonstrate how bad things were in 2004. There were massive miscarriages of justice on a daily basis. Some lawyers just didn't have a clue what they were doing. They were not criminal lawyers at all. I used to accept referrals where miscarriages of justice had occurred. And I remember acting for a woman who'd been sentenced to life imprisonment for murder of her husband. Now, the evidence against her was completely circumstantial. She asked for a lawyer at the police station. The only lawyer she knew was the one who'd done her mother's probate. He told her that she had to answer questions, that she didn't have a choice. She answered questions, and she ended up with life imprisonment. That's when we took over, and at the retrial, well, the Director of Public Prosecutions didn't even offer any evidence. So that was how bad things had got. So in 2004, the government offered a £1.2 million grant for someone to create a quality assurance process for publicly funded criminal defence lawyers. And that contract was won by the Institute of Advanced Legal Studies and Professor Avram Sher, who David has just mentioned. Now, Avram is my line manager, so I've got to say nice things about him, but truly, Avram is the nicest, most honest, cleverest person I think I know, and I'm sure that Jeff would agree with that. Jeff knows him going as far back as I do. Avram is the father of peer review as we know it today. So in 2004, Avram placed an advert in the Law Society Gazette. I applied and I was appointed, as indeed I think was Jeff.
And Philip, may I interrupt you for a moment?
Yes, sure.
So just tell me about the technical problems on your side. Can you see the slides?
No, I can see a screen that says 6 things: selection of firms for peer review. Yeah,
that is the slide. So perhaps if you could move on to covering the content of this slide, and then ask me when you'd like me to move to the next slide.
Yes, sure. Right. The selection of firms for peer review is done in one of 2 ways. First of all, as was mentioned at the outset, the legal aid agency's target is for every firm to be peer reviewed in a 3-year cycle. So unless you're within 3 years of retirement, you're going to be peer reviewed. And then there's another type of peer review, which is the targeted peer review. And targeted peer reviews are where there are concerns about a particular type of firm. Now, the selection of files from that firm is handled by a system, a program created by Microsoft. Here again, I'm talking about crime. Crime files are divided into police station work, magistrates court work, Crown Court work, guilty pleas, not guilty pleas. So the program developed by Microsoft was a random selection process to select across the board example of the work of that particular firm. All these are closed files, so they each have a unique reference number that the legal aid can establish applies to that particular file. So there's no way of booking the system. The supplier then has to send those 12 files to the legal aid agency. Now, we live in strange times with COVID. It used to be when I was peer reviewing, when Jeff was peer reviewing, that the reviews were carried out in London at the Institute of Advanced Legal Studies. But in the course of streamlining, a couple of years ago, we were allowed to start reviewing distantly. That is, the files still came from London, but you could review them in your own office or your own homes. And now, after COVID, well, at the moment, there are no peer reviews being carried out because of the risk of contamination from touching the papers. But I think the new normal will be that all reviews will be carried out remotely by the boxes being delivered to the reviewer. Now, reviewing the files, there's no set protocol for this. Everybody reviews the files in the way they feel most comfortable. My practice was to quickly flash read all through the files just to get a feel for the way that the firm did the work, and all to make sure that I got the right files, the right number of files that were capable of being reviewed, that I didn't have a conflict with the firm. And then I'd go back to the first one and I'd make careful notes. There again, everybody did things differently, but I would make careful notes. And then after I'd finished the files, then I would use those notes to compile my peer review report. Time recording, there's no strict requirement to time record because we are paid by the hour or by the day. By the scale of things, it's not well-paid work, but it's regarded as an honour and a great privilege to be a peer reviewer, because it's a great honour to look at the way other people do the work and you think, wow, that's good, I'll do that. So it's, I think, Jeff might be able to correct me on this, it's £57 odd an hour, and that works out at 360 odd pounds a day, plus expenses. So next slide, if you're ready, David. Why are the LAA stepping up peer reviews? The short answer to that is because it works. We've had lots and lots of precursors to peer review. Simply, they didn't work. They didn't work. For the reasons I've already stated, they were self-completing tick boxes. The LAA tried everything before they went to peer review, because the cost of peer reviews, getting people to review their own files doesn't cost them anything. Paying an experienced lawyer £365 a day was something that they didn't lightly take on. But it worked. It took them 5,000 peer reviews and until 2017 for the legal aid agency to accept that peer review worked and that it was the only way forward. So that was in 2017. Obviously, we had to build up steam. We're still building up steam. I had, in 2017, 25 crime peer reviewers. I now have 40 crime peer reviewers. The process has been streamlined so that reviews can be done more quickly. So they're stepping up peer reviews because peer review works. Next slide. Right, ratings, the scoring system. Right, so I've done my peer review. I've been through all the files. I've made my notes. I then have a pro forma to complete. I don't know whether you've covered this, David, but these are public documents. They're freely available on the internet, I could provide the references at the end if that's helpful. Right. So the ratings. I have the form to complete. I've been through the files. I now have to complete the form. The ratings are from 1 to 5. 1 is excellent, 2 is competence plus, 3 is threshold competence, 4 is below competence, and 5 is failure in performance. And so I go through the files, and there is also a checkbox which describes each of the component parts of a file, such as communication with the client, advice on plea, quality of correspondence, proactivity, all the things that you would expect or should be entitled to expect in a provider of publicly funded defence services. And you go through these and you rate each piece of work on that scale of 1 to 5. And then once you've rated them on 1 to 5, then you take an overview of the whole file sample. And again, you decide, is this an excellent firm? Is it above competent firm? Is it a threshold competent firm? Is it a below competent firm? Or is it failure in performance? Now, if your firm is rated as excellent or competent plus or threshold competence, then that's the end of the matter. But if your firm is rated as below competent or failure in performance, then you are entitled to what in PR speak we call the representations process. In simple words, it's an appeal process. So what the supplier does, and again, it's on a form which is available on the internet, the supplier makes representations. So it could have been that the reviewer found that the quality of legal advice was a major concern. And the supplier might make representations in response to that by saying, oh, but we've been rated by Lexel, we've been rated by, there are 101 different rating systems of lawyers. They might say everybody else has regarded us as really good quality. The answer to that is that peer review trumps every other quality assessment process, and that is actually written in the process paper for peer review. Now, So you make the representations. At that stage, the original reviewer will either agree that the firm should have been rated higher than it was, or say, no, I've listened to what you've said, but my original decision stands. Now, at that point, the issue is handed to an even more senior peer reviewer. We call them SPAMs, which isn't very flattering, but it's an acronym for senior panel members. And the SPAM then either validates the report, that is, agrees with the original reviewer, or sends it back to the original reviewer with advice, and that may result in the rating being raised or remaining the same. If the rating remains the same, then that's the end of the process. Right, next slide, David, if you may. Right, I think at this stage we agreed that that Jeff would take over. Is that right, Jeff? Or do you want me to?
Yeah, that's fine. That's fine, yeah. Phil. Thanks very much for that. Examples of good practice. The first thing to do when you get a request for your files is to think about what you're going to be sending in to the peer reviewer, and ideally you want your files to be easily understood, and if that is the case, then they will appreciate the work that you have done on your client. I often use a phrase, perception is all, and picking up the file in the first place, you get a feel for what it's going to be like. Sometimes you get the wrong indication. Sometimes a file looks pretty ropey, but in fact turns out to tick all the boxes. But at other times, you can be misled into thinking that it's going to be good, and it turns out to be a bit of a dog's dinner. So presentation of files is enormously important. It's also important to remember currently that we are dealing with we are in the electronic age, and you may very well either work almost exclusively electronically, or you may very well work on a paper file, but then store all your files electronically. And this can present quite a problem. First of all, how are you going to send your files in to the LAA for the peer review process? Fine for you to do that on memory sticks or in some other way. But if you convert it to paper, as one I saw a few weeks ago, you've got to be very careful that in fact it relays the appearance of the file in a true and fair manner, by which I mean that the file that, or the group of files that I'm thinking about had obviously been stored electronically. The job had been given to somebody, maybe a junior, I don't know, to reproduce those files on paper, and then they've been sent in for the file review process. And it was at a stage after that that I first came to see it, when in fact the firm was going through a representations process because of a flaw. And I must confess, the files were very difficult indeed to follow. They had been printed out, they had been done back to back, no account had been taken of the various sections that most crime practitioners will allocate to their files. So you'll normally have a correspondence clip, or traditionally we've had correspondence clips. We've had prosecution evidence in one folder, defence evidence in another, and then miscellaneous papers, maybe legal aid and such like, in another folder. So how you present the file, it having been stored or maintained originally in an electronic manner, is most important. So peer reviewers used to, I don't know if they still do, I haven't been a peer reviewer for a couple of years, but I've kept fairly close to the system. And I know one or two of the peer reviewers who are still working in the system, and so I pick up information from them. The system not having changed substantially in the last few years. We always used to talk about the pickup test, and the idea was that you receive the file, that you would look at it, and within a few moments you knew who the client was, you knew what the charges were, you knew what stages the process had, or the client had gone through, whether he'd been represented by that firm at the police station, whether he'd been represented by anybody at the police station, who had dealt with it at the magistrates court, and who at the Crown Court. Of course, things are very different these days, because there used to be an adjournment culture in the criminal justice system, which has almost been eradicated. So the files themselves tend to be, certainly in terms of the number of hearings, tend to be much more brief. So do think about the way that you are presenting the file. And this is also important. If you have standard documents, so for instance, you have a practice brochure, maybe a legal aid leaflet, a police station leaflet, a appeal advice leaflet, and a complaints brochure, which you would normally send out to a client either at the beginning with your client care letter or at the end of your end of case letter. You wouldn't normally keep, in my experience, those sort of documents on the file itself. So do think about those documents and send those maybe in a covering letter to the LAA to say, look, these are the files, but you should realise that we're referring these files to, for instance, an appeal advice leaflet, and this is the leaflet that would be sent out. Looking at the police station practice, it is surprising how many firms still do not use a police station pro forma. My firm uses a very detailed pro forma. It aims to deal with just about everything that could ever happen at the police station. I've had it criticised because people say, oh, it's far too lengthy, far too involved. Well, that's fine. But if you do use a pro forma, make sure that you or your solicitors and other staff do complete all sections of it. And very important indeed, to keep a timed record. What the LAA, when they do their audits, like to see, and peer reviewers very often are exactly the same, they like to see where the request has originated from. So is it an own client that's contacted you? Have you been contacted by the police direct, which still happens occasionally? Has it come through the DSCC process? So that will be looked for in your police station pro forma, or your handwritten notes, whichever is the case, your freehand notes. And then after that, the police station booklet, and indeed the file after that, should read almost like a book. So somebody could pick it up, see, oh yeah, this firm attended the client at the police station. This was the advice that they were given. And remember, advice on its own is not sufficient. Advice is very important. It's absolutely crucial to peer review that you have advised and recorded the advice and given written confirmation of your advice to the client. But it's also important that that advice should be justified. And that's a term that I use constantly to trainees that pass through our office. Always be looking to justify what you have done, especially the advice that you have given. There should be clear and comprehensive communication with the client. So you should do clear letters which repeat what the client has been told either in the police station or at court or in the office, not so much in the office these days. And you should again be prepared to justify that. We find that using standard letters with different alternatives within the standard letter is a good way to keep the fee earners on track, and so that it assists them as an aide-memoire. Do we need to put in a copy of the legal aid order? I know there's the LAA have said, you don't need to put in legal aid orders because we know when legal aid has been granted. However, I would suggest that it's good practice, both from a peer reviewer's point of view and from your own file point of view, to be able to pick up a file and say, yes, we have definitely got legal aid on each one of the offences this client was dealt with for. A clear statement of the charges is, in my view, vital. The number of times that I've got to the end of a file and I've gone back to the beginning again and tried to find what on earth it was that the client ended up being charged with. Very often, as you know, the work in the police station or the reason for arrest changes during the process in the police station, and the client might be charged with something differently. Or if he's charged with whatever he's charged with from the police station will often change at court. And it's amazing how many times you pick up a file and you really don't know what the client has been sentenced for at the end of the day. Sometimes you don't know what he's been acquitted of. So do keep a note of the offences for which he was originally charged, those that fall by the wayside, and those that maybe he ends up getting convicted in respect of. Make sure that there is prosecution evidence on the file to support the whatever charges he's been dealt with for. I also advocate being persistent in obtaining instructions from the client. We all know that there are clients that maybe you see in the police station, and you end up with a trial, and the only information you have about his defence is maybe what he said in the police station in an interview in the police station. What would be expected in those circumstances is that after seeing the client, maybe initially at court or from the police station, you write to them and say, we would now like to see you in the office, or we would like to get your further instructions one way or another. You don't need to see them in the office, you can do it remotely on the client's PC or whatever. But if you have no clear instructions from a client, and especially if the case is adjourned for trial, a peer reviewer would expect you to have made one or more, depending on the time scale, attempts to get some instructions from the client. I have seen some very questionable views expressed by some peer reviewers. For instance, I remember seeing one that said that a peer reviewer, this is, who marked a firm down for not having sent the client a copy of the, as it was in those days, the prosecution statements. I would say that that was really not necessary. There will be occasions upon which a peer reviewer, in my view, will overstep the mark in what they expect. Now, that if it ends up with a 3, then that's the end of the matter. But if it's a 4 and that is the situation, then that is a time at which you might either want to be challenging yourself or get some advice from an organisation such as DG Legal on the outcome of the peer review. Proofs of evidence, always great if you see them and if they're well constructed. Obviously not so essential these days, given that most clients go to court and are dealt with maybe in just one hearing. There's no opportunity for a proof of evidence. But where it is appropriate, it really does help the peer reviewer to take a favourable view of that file. Likewise, defence witness statements in trial cases. We still go through the practice in my firm of where we, on the occasions when we do prepare a proof of evidence or a defence witness statement, of sending 2 copies to the client and asking him to sign one and send it back. It's not absolutely essential you do that, but again, that will impress the peer reviewer. Another aspect that I always think is good practice is that a note, I've already mentioned this in passing, a note of the advice given and confirmation in writing is sent to the client in a timely manner. What's timely mean? Well, it depends on the circumstances, which is precisely why the phrase is used in a timely manner. Usually if it's a client that's been into the office within a few days, I would hope no more than a week of the client being in or having been seen at court or at the police station, you should be expecting to get the information to the client. If it's sent by email, fine, as long as you've agreed the means of communication with the client. An absolutely essential thing in peer review, and I can't overstate this, is appeal advice. The number of times that you see in an end of case letter saying, oh, you went to court, you got this brilliant result, so of course there's no question of appeal. That is not sufficient. You should be telling the client his rights, and his rights are that even if he got a brilliant result, his rights are that he still may appeal it. And that applies in both the Magistrates' Court and the Crown Court. So what we have is we have a very detailed appeal guide leaflet that we send out to all clients who have either pleaded guilty or been convicted, to say exactly what their rights are insofar as appeal, and it covers not only the merits of the appeal, which most people talk about, but also the right of appeal. Also mentioned that in Crown Court cases there was some Court of Appeal documentation many years ago which said that quite clearly that counsel, where you use counsel, or indeed HCA should be giving written advice on whatever the outcome of the hearing in the Crown Court is concerned. And certainly our briefs to either our own HCA, we do internal briefs incidentally, our briefs to HCAs or to counsel will ask for or remind the advocate that they should be prepared to do a written advice on appeal. So passing on to examples of poor practice. Well, obviously the reverse of everything I've just said, you could argue might be seen as some poor practice. A disorganized file clearly is not good. It suggests muddled thinking and chaotic working. And so try to make your presentation of the file as organized as possible. Don't think it's a good idea to pick up all your papers and throw them up in the air and say, let him sort that lot out. I always say, try and make a friend of the peer reviewer. If the peer reviewer loves your files, he'll love you and he'll maybe give you a good score. I'm not saying the opposite applies, but use your own judgment on that one. Evidence of poor case preparation would be, for instance, where there's no instructions from the client and no attempt to get any instructions. A failure generally to either give advice or to confirm whatever advice has been given in writing to the client and to justify that. I suppose the obvious one is in the police station. I think more and more people are tending to give no comment interviews. It certainly didn't happen many years ago. In fact, you were singled out in our area if you were a firm that had a number of clients who gave no comment interviews. But just advising a client to give a no comment interview is not sufficient. You must also make it clear that you've advised the client what other options he or she has. That can be done quite simply in a tick box. You don't have to justify every one of those, but you should be justifying the advice that you have given in one way or another. Let me pass on to, what was the next section, David? Oh, specimen client care letters proformas. I don't know if you've got that up on a slide, David. Don't know if David's there. There we go. Oh, tips and pitfalls. Okay, let me take that first of all. Tip one, I've got as some of the files may not be available. When you get the list from the LAA, you need to look at the files that they are asking for. If they are currently maybe in a billing process, or they are not available for some other reason, maybe an appeal is pending, then you should be going back to the LAA and advising them that straight away. And they may very well ask you to, depending on which file in that series is the one that's missing, they will decide how important it is that you put a substitute file in. But you don't choose the substitute file, they choose the substitute file. There are some files which a peer reviewer should not be reviewing, and that would be, for instance, a file which started off with another firm and has been moved to yours, or vice versa, started off in your firm and the client has at some stage in the proceedings moved to another. So you should be looking out for that, and also advising the LAA, look, this is the situation, what do you want us to do? Let them make the decision. You just come up with the issue, whether it's a missing file. If it's a missing file that you just can't find, clearly you must also tell them about that. But if you've got more than one, or certainly more than two missing files, then there will be extreme concern at the LAA. I had an issue the other day, which is pending at the moment. It was one of these county court or civil cases, which is billed under the criminal legal aid billing system, and that had been pulled out and had been reviewed by the peer reviewer. Now, in my view, it's quite wrong that it was included in the peer review. Ideally, the firm would have flagged it up at the outset and said, look, are you sure you want this file because it's this? But it having been included in the peer review, I think the peer reviewer should have immediately spotted it and said this should not be reviewed, and that issue has been raised with the LAA, and I believe that they may very well be looking at that at the moment, or certainly they should be, because it's been raised with them. What the outcome will be, I don't know. You should understand that peer reviewers are advised to review down but not up. So what that means is that if you are asked for a Crown Court file and you also dealt with the client in the Magistrates Court and in the police station, then you must send all three files. Some firms will just open a file in the police station and that file will run through as far as the case goes. Other firms will actually open quite separate files for each stage of the proceedings. So whichever system you adopt, all the papers relating to the beginning of your dealing of that case with that client should be sent for the peer review. If, on the other hand, you are asked for a police station file in respect of a case which has also gone on to the Magistrates Court and or the Crown Court, you don't need to send those other files in, because peer reviewers do not review up, but they do review down. Do your best to avoid the representations process in the first place. It's so much easier to spend a couple of hours looking at your files before you send them in for review, rather than spending a lot of time and effort and heartache in trying to get yourself out of a 4 or 5 rating, which is the last thing you want. So it's worthwhile. Don't just give it to the junior to say, right, find these files and get them sent off. I would advocate that you sit down and you make sure that the file is a true representation of the work that you have done in respect of that matter for that client. And if it's not a true representation, you need to ask yourself, what is missing? And if something is missing that you have done, but it's not there on the file, then my advice would be that you add that to the file, but you make it very clear that the document is being added. I've also gone as far as to say, if there has been an attendance and the attendance note is missing, then I would certainly put in an attendance note, which may be from 3 months, 6 months ago, whatever it may be, but I would make it very, very clear in that attendance note when it was prepared. So if it's an attendance note that's on your electronic system, say, but it's for some reason it's been missed off the paper file and you're sending in a paper file, then clearly you can just print out a new copy and stick that in. If it's an attendance note that has just completely disappeared or maybe even never been done, then I would get the person who did the attendance to do a note at that stage, but I would make on it clear, please note this attendance note was prepared on such and such a date by the fee earner who did the attendance, and it is a true representation of the advice and the work that we did for the client at that time. And then it's up to the peer reviewer as to whether they accept that. I'm sure that in the majority of cases, the peer reviewer would see from other evidence on the file that yes, it does make sense that that is the advice that's given. But I know some people might take issue with that, but that's the way that I would approach it. Just looking for, I'm conscious of the time passing, we're nearly at the end now, just making sure that there's nothing. Can I just say a word for file front sheets? Those of you that remember the days when the CPS came to court with a paper file and they had a wraparound cardboard wrapper, and that was their file front sheet. And I have always used and advocated the use of file front sheets. So I always say with our paper files, you can pick up that file, you can look at the front of it, and you can see who the client is, what his or her details are, any problems that client has, maybe hard of hearing or some other disability. You see where they live, you see whether or not they're working. All that appears on our file front sheet, whether or not we've attended the police station, the charges and the process that's happened to those charges, for instance, mode of trial, and also the principal attendances. Those will all be noted on the front sheet. So a peer reviewer receiving one of our files should be able to, I say should, because I don't do all the files, which is perhaps just as well, should be able to see all those details without even opening the file. And that, to me, answers the pickup test. And if everybody did that, then there would be a lot less problems, in my view, when it comes to a peer reviewer understanding and appreciating what work has been done for the client. Receiving a rating of 4 or 5, my tip there is get some advice as quickly as possible. It's absolutely crucial and expensive for you to end up with a 4 or a 5. Obviously, it could ultimately, if it's a 4, lead to a loss of contract. It will certainly lead to a further peer review, which is going to cause you even more problems. So do get some initial advice on, look, are we really as bad as he or she says, or are there issues that that have been overlooked or in some way misunderstood by the peer reviewer? And it's certainly every likelihood, well, I don't want to overstate it, but there is a good chance that somebody with a 4 or a 5 may just be told, look, we think that you should go through the representations process on this because we think that there is room for questioning the outcome. So I think finally, we've skimmed over, we haven't referred to, apart from in passing, specimen client care letters, proformas and forms. I'm a big advocate of them. We're a long way from, I don't know if many of you remember the phrase, but we always used to talk about the back of a fag packet. The instructions are on the back of a fag packet, and that's the way it used to be. It can't be like that now. I would suggest, if you haven't got a whole host of pro forma letters, pro forma documents and other forms, then you should at least be knowing what there is out there. On screen now is a few places you can visit online, not exhaustive by any means, but certainly there's some useful documents on there. There's the website, the LAA website, which deals with audits and mentions peer review, and also has one or two links out of that to other places. One of them being the next one in line, the peer review process document, June 17, which itself is a useful document. I think this might be about to be updated, but don't take my word for that. But there might be a 2020 version on its way.
Yes, there is.
Remains to be seen. Ah, thank you, Phil. I
Yes.
thought you'd know, but I didn't like to say with. I'd had my tip off from Phil, so I didn't want to come up with that. But now he has, then that's fine. It's official. What will change? I'm not too sure. I hope
Not
one
a
thing
lot.
that does change, Phil. That's to be expected. But I hope one thing that does change, that in my day as a peer reviewer, we used to have some really good training sessions when all the crime peer reviewers would get together and they'd talk about, they'd be told by Professor Scher what the outcome of all the reviews were, and he would express concerns if somebody was well out of line, or a few people were well out of line, either too harsh or too soft. And it would be a really useful session. Unfortunately, having gone through the austerity, the training, in my experience, almost came to a halt. And unless it's been restarted recently, it will mean that for some time to come, in my view, the peer review process isn't as good as it used to be. But I'm sure Philip, if he's provided with, and Professor Scher, if they are provided with the funds by the LAA, will be addressing that issue.
Yes, they will recommend. They will recommend.
Sorry, Phil.
Yeah, they are going to recommence. Consistency training will recommence.
Consistency training, that was the word I was searching. I couldn't just bring it to mind. Yeah, consistency training. So important in my view. And we had some really good debates on what peer reviewers were doing and what they should be doing. And it needs to return, in my view. It was one of the pins of the whole system. It kept everybody on track. Occasionally now you see a peer reviewer, in my view, going off on a tangent. And when I was reviewing peer review reports, I would raise that with the peer reviewers and would maybe have a bit of a barney about it, about whether it's right or whether it was wrong. But at least it was discussed. So that's it. Finally, there's the very old but still very useful. I remember this from when I first started doing peer review, improving your quality of guide. It's been updated once, maybe twice, but it's still got a good few tips in there for you to look at. So I'm over my time. I apologise. I could speak for hours on various things, but I hope that has been useful.
Okay, thank you very much for that, Jeff. There's just a couple of things that I'd like to cover, and then pick out some of the questions. We can't cover all of the questions because there's just too many of them. But the first thing I wanted to say is we have produced some very detailed guidance to peer review. It's effectively a 22-page guide written by Jeff, which we could have gone through today if we had 3 hours, but nobody wants to do 3-hour webinars, so we are going to send this to you. Also, there's an Appendix A of various peer review documents, and included in that bundle are example peer reviews and an example peer review report, which I think is absolutely excellent. And then perhaps the best thing, which is extraordinarily generous of Jeff Bell, he's giving up effectively his intellectual property here. He's produced a bundle of their proformas, template attendance notes, client care letters at each stage of the case, so police station, Mags Court and Crown Court. So thank you, Jeff, that's extraordinarily generous of you, and we'll get those out to people over the course of the next few days. Now, let's move on to some questions. The first question I got, which was asked before the webinar, I understand that if a firm fails with an appeal, a fee is payable in the region of £1,400. If we win the appeal, we will have incurred significant costs. Will the LAA pay our costs? And I've asked that question, and you can put in a compensation claim. In the FAQs, which are going to be published on our website, I will put in the link to that. It used to be known as the ex gratia claims. It's now known as compensation claims, so that is possible. I've got a question for Philip here. Question is, morale is rock bottom. Could you consider lowering the bar so we aren't expected to write time-consuming, very long advice letters that the client never ever reads? Philip, could you comment on that?
Yes, it's the poison chalice, but I'll do my best. The short answer is no. We can't lower the bar. Quality is quality. And that would have to be the official line. My own view, and this is what I say to my peer reviewers when they ask the same question, is, well, I tell them a little story. When I used to play amateur football, and we were a decent team, and we had a good goalkeeper, Johnny, but he was really, really short. He could stop anything on the ground, but anything just under the bar, it was bound to go in. And then one day in the long grass behind the field, one of the team, not me, found an old crossbar that was warped. It had a big dip in it. And Johnny said, look, why don't we use that crossbar? That would suit me fine. And we said, oh, everybody would notice. No one will put up with that. But anyway, he insisted. We did put the crossbar up. We conceded far less goals, and we even got so bold that when the opposing team went into the changing room for the Bovril at half time, we used to carry the crossbar across the field to the other goal, and nobody noticed. So the moral is, you can't lower the crossbar, but maybe you can just bend the crossbar a bit and no one will really notice.
Okay, thank you for that.
If I could add on that,
yeah.
David, if I could just add to that, which of us is going to be saying to our client, well, I'm not being reviewed to quite such a high standard these days, so I'm not going to do quite such a good job on your case.
Yeah.
Okay, thanks for that. Question about peer reviews. Have peer reviews stopped during the COVID-19 crisis? And the answer that we've got is that peer review has been paused as part of the LAA's COVID contingency response, and providers have been notified that this will restart from the 1st of August, where they'll be focusing initially on priority reviews. For example, second reviews, which are now due after a first below competence review. Okay, let's also just have a look at the chat, and I'll pick out a couple. I'm not going to go through all of them because some of them would take a little bit of time to answer. One, David, would these links remain so that we can view them, please? Yeah, you'll get a copy of the slides. We'll put the links in the FAQ, so that's not a problem. We've got a couple of critical comments, which I would like to replay the video and just listen to those comments again, and then we will ensure that a written answer is provided. I think that's probably more appropriate than posing the question just now, or the comment rather. Question here is, this is a question for either of you. In future, can files be sent digitally as we are trying to work with paperless files?
Yes, they are. Sorry, Phil, you
carry on, Jeff.
Well, my understanding is, and Phil will correct me if I'm wrong, that the LAA some time ago said that if a firm works digitally, then their work can be reviewed digitally. The problem may be finding peer reviewers who are able and comfortable to review them digitally. But that's the LAA's issue, not the supplier's issue.
Yeah, that's the case. This was very problematic in the early days of virtual files. We now have protocols which set out how the file should be constructed, and it's working a lot more smoothly now.
Here's a good question. Does the review take account of whether the standard letters are understandable by a lay client rather than just whether they are legally correct?
No, most definitely, yes. The peer reviewer would expect the letter to be written in terms that would be understandable to the client, and in a manner also. So more and more we're getting cases where the client's first language is not English, and sometimes they have no English at all. What I've always suggested is that you use one of the internet, Google Translates, but you know, so you write your letter in English, you then go onto the Translate app or whatever it is, and it's translated. But I would always advocate then translating it back again to make sure that what it has translated is in fact what you meant to say. But that's slightly off the point. Certainly it should be in terms of English to English speakers, then it should be at a level they would understand. Agreed
with that. I once saw a letter to a young, vulnerable youth client who was on Rationale and goodness knows what counselling, and the solicitor wrote, the juxtaposition of the locus in quo vis-a-vis the CCTV is questionable.
Yeah.
For
yeah.
Okay, thanks for that. Let's just have maybe one or two more, then finish up. Question about briefs here. Are briefs, presumably briefs to council, essential? We invite council on CCDCS and send an email explaining essential issues.
Well, I was asked this at one of the training sessions I did, and I said, well, your email is the brief, is it not? You know, it might not be in the format that one would expect a brief to be in, and it may not be as comprehensive. But surely, one way or another, you've got to pass the instructions to the barrister, if it is a barrister, or HCA. And as I say, we do it in any event with our in-house barristers and HCAs, that we always insist. And what we have a pro forma brief, and all you need to do is just fill in the blanks and just attach a few documents, for instance, a proof of evidence, if you've got a proof of evidence. So just think a little bit more widely about the term brief. It doesn't necessarily have to be some very formal legal document. It could be an email.
I agree with that. The days of pink ribbon have gone. All that's required is that in whatever format the instructions are adequate.
Yeah. Okay, there's a good question here, and I think even I know the answer to this one, because maybe some of the guidance that's sent with the peer reviews doesn't necessarily make sense. The question is, interesting point that Jeff made about sending all files regarding a case. If you're asked for the Crown Court file and send the mags and the police station file, and it's obvious why you have to do that. But if asked for a police station file, no need to send magistrates or Crown Court file. Unaware of that. Last peer review we were asked for a number of files and that's all we sent. There was no request to send the other connected files, and we were marked down for not having sent files we were never asked to send, which seems petty. Well, I mean, I'll ask you to comment, but clearly if you're just looking at a police station file, why would you need to send the mags and the Crown Court file?
No, you don't. I'm not sure that's what was being said, David, but if it was, then quite clearly that was wrong. But I think it in the letter.
No, it's not anything. It's not anything you said. What the questioner is getting at is the peer reviewers allegedly being critical for not submitting connected files. But I mean, that's got to be a mistake, isn't it?
Yes, exactly. I believe that Phil will probably know better than I, but the letter which is sent out by the LAA asking for the files asks you for linked files and goes so far as to explain what linked files mean. That's the term that they use, linked files. But as I say,
that's correct.
But they will review down but not up. That is very clear, unless they've changed it, but I don't think that's the case.
Okay, there's a final question which I think I can comment on. What happens if a firm fails in its appeal? Does contract for the firm get withdrawn? Well, the answer is that if it's a first time that you've got a 4, then you get a second opportunity. And what happens is the follow-up file review will take place in approximately 6 months' time. If, on the other hand, you've got a 5, there would be a fairly immediate new peer review. Now, if you were to get 2 4s in a row, then ordinarily the LA would then seek to terminate the contract. But then you would get a right of appeal in relation to the termination of the contract, and that appeal would be considered by something known as the contract review body, which is a little bit like an informal tribunal. And you will
remember that I think last year, David, we had such a case that I'm aware of, where the contract review body was about to hear the case. It was referred to DG Legal, and we picked up the fact that they had asked for a bad sample. They'd asked for files which had been completed prior to the given date. So that was a successful representations to the contract review body.
Yeah, that's great. I think there's a couple of other ones which we will answer in the FAQs. Now, in terms of your questions, if you have any further questions, and I'm pleased to see that the overwhelming majority of people are still with us. If you have any further questions, please send the email to the address you can see on the slide, which is teamadmin@dglegal.co.uk. I think we'll have a cut-off of 5 p.m. on Monday, and then we'll try and put together all of the answers and the questions, and also address the couple of critical comments that were made in the chat, hopefully by the end of next week, if not early the week afterwards. So once again, I'm going to finish on the fact that you're going to receive a lot of materials, including some very, very helpful template police station mags and Crown attendance notes and Specimen client care letters, etc. Please do have a look at that. If we were selling this material, I don't think it would be particularly cheap, but I'm very pleased that we are able to give it away without any charge. Okay, so we've come to the end now. Jeff, you are hosting of this at the moment, so you're going to need to end. You're going to need to end this. So if you can use your cursor to bottom right hand corner, you should be able to see.
You should have told me that at the beginning.
Well, we're trying to get your video working.
Yeah. Okay, I'm going to end it now unless anybody says no. Oh, thanks, Bill. That's a message from Bill Waddington there. And thanks to everybody for their very kind comments. Shall we have a countdown? 5, 4, 3, 2, 1. Bye.
Bye.